Good evening, everybody. I'm your host, the Supreme Litigant, and I'm back again. I hope everybody enjoyed their Friday. Before I get into the topic of this video, I want all of my new viewers, if you haven't already, please go ahead and hit that subscribe button and that like button. I'll give y'all a second to do that. All right, let's jump right into it. um, this video, I'm going to be talking about equity some more, and I'm going to read over a little of the merger of law and equity courts because again, I remember when I told y'all that these courts were separate courts, so they have their own rules of procedure. I'm going to show you cases that prove my argument. I'm going to start with this one. Let's go up here. I'm going to give you the case citation. This is an Alabama Supreme Court case that was decided in January 2022. This is the case citation, Ex parte versus Grimmett. This is a divorce case. I know y'all like, what does divorce have to do with equity? I know, right? But anyway, I'm going to scroll down. I'm going to read y'all about 2.5 paragraphs or a paragraph and a half of this. Where is it at? I might have went too far. I think I went too far. Yeah, I did. So let me go up some more. Where is it at? I just had it. Give me a second, y'all. I might have went too far. It should be down here somewhere. Here it is right here. Okay. Before 1973, Alabama cases in equity were handled under a different type of court procedure from cases at law. Pay attention, y'all. At law means common law. They had their own rules of procedure. Courts of equity and common law had their own rules of procedure. And divorce cases were governed by equity procedure. In equity procedure, a case was initiated by filing a bill, the rough equivalent of today's complaint. And composing a bill was a demanding process. The stating section had to contain avertment of every fact. So when they're saying stating section, it's just like the ultimate fact section of your complaint. The stating section had to contain avertment of every fact which would enable the trial court to arrive at a proper settlement of the issues. That is, the bill had to set forth every material avertment of fact necessary to the complainant's right of recovery. It's always about the facts, y'all. I don't care what it is. Whether it be a motion, a petition, an affidavit, a writ, I don't care what it is. It's always about the facts. So if you're going to draft a bill in equity, you need to plead facts in equity, and you need to request a remedy that is equitable in nature. Facts not alleged in the bill could not be a basis for relief. They were deemed to not exist. That applies everywhere. I don't care what nature of the action is. If it's relevant to your case and it's going to prove why you are suing for what you're suing for and why you're asking for the particular remedy that you're asking for, put it in the complaint. If it's not going to prove that, don't talk about it. Act like it never existed. That's how you got to do it, y'all. And if they ask you about it during a deposition, just act like you don't know what the hell they're talking. It's irrelevant. That's irrelevant. We're not here to talk about that. That's irrelevant. We're not going to talk about that. Chancery does not grant relief in the absence of appropriate avertments. Explaining this general principle of equity procedure, proof without avertment is not available for relief. Thus, in that procedural era, the evidence at trial had to conform to the bill's allegations, meaning the evidence had to be relevant to the allegations in the bill in equity. If it wasn't relevant, the evidence is irrelevant. You can't even talk about it. It's not going to even get admitted because it's irrelevant. So why are we talking about it? See what I'm saying? The evidence was never allowed to supply omissions and defects in the allegations. Consequently, The allegations had to be such as to justify presentation of the evidence. All of that changed in 1973. In Alabama, that is when they merged these courts. I'm not sure when, what year for any other particular state, but in Alabama, 1973, that is when they did it. In that year, this court merged law and equity procedure. I told y'all they had their own rules of procedure. You couldn't go into a court of law and get a remedy that was exclusively reserved in equity. You couldn't do that. You had to go to a court of equity to get that remedy. And you couldn't go to a court of equity and get a remedy that was exclusively reserved to a court of law. You had to go to a court of law to do that. In that year, this court merged law and equity procedure when the court adopted the Alabama Rules of Civil Procedure. See Rule 2, Alabama Rule, Civil Procedure, blah, blah, blah. And this right here is going to support my conclusion on why I'm about to say what I'm about to say after I read this to y'all. The legislature has specifically authorized this merger 2 years earlier. See Act number 1311, Alabama Acts 1971. This is what I think that they are doing, y'all. And I think I'm 100% right about this. The legislature is creating administrative agencies via statutes and investing quasi common law jurisdiction and quasi equity jurisdiction in these administrative agencies. That's how statutes become used in so-called equity. That's the only way. I haven't seen a case yet that tells me that statutes originally come from equity, or or they're not. I can't even put the words. I don't want to confuse nobody, so I'm just gonna leave it alone. Anyway, let's see. I'm gonna point out to y'all just something else, and then that's gonna be it. Let me see. It says Rule 28, Alabama Rule Equity. See this? You see this right here? This was a Alabama rule in equity, in a court of equity or chancery, or so to speak. This was a rule, but they repealed this rule and they have condensed all of the equity rules and the common law rules in the Alabama Rules of Civil Procedure. And they did this everywhere. They did this, in my opinion, to confuse y'all, because you don't know if the so-called judge is acting in an executive administrative capacity, or if they're acting as a justice, or if they're acting as a chancellor, which is in a court of equity. In courts of equity, judges are called chancellors. All right, let's go. I'm going to be studying equity a lot, by the way, a whole lot. I haven't studied any, very little. I'm going to be studying this a lot, just to let y'all know. And I want y'all to see something. I'm gonna scroll through some of this, and I'm gonna tell y'all why that I think all of you should be studying equity and learning how to draft a bill in equity. The public trust doctrine maintains that government holds untaken wildlife in trust for public use, and that government owes a fiduciary duty to manage such resources for the common good of the public as beneficiary. Now, where is it at? There's another one. This one right here, this really stuck out to me. This case right here really stuck out to me. I need to go and read this case, and so do y'all. There's the case citation right there, and there's the case. The theory is that a public officer assumes the same fiduciary relationship toward the citizens of his community as a trustee bears to his cestui trust. The Supreme Court holds that an action by a trust beneficiary against a trustee for breach of fiduciary duty was within the exclusive jurisdiction of courts of equity. You can, what I'm trying to get y'all to understand is you can sue them when they breach their fiduciary duty. In other words, when they violate the Constitution, you can initiate a lawsuit against them in equity, and you can get damages from when they do that. I have to find that case on that. I'm going to be studying equity a lot, a whole lot. It is a well-established principle of equity that a third party who pays money to a fiduciary for the benefit of the beneficiary, with knowledge that the fiduciary intends to misappropriate the money or otherwise be false to his trust, is a participant in the breach of trust and liable, therefore, to the beneficiary. And there's one more case that I want y'all to see. This is a Supreme Court case, just to let y'all know. Where are we at? I'll read y'all this first, and then I'll give y'all the case citation. Lashes is a defense developed by courts of equity to protect defendants against unreasonable prejudicial delay in commencing suit. In equity, it's called a suit. It's not called an action. An action is called, in courts of law, it's called an action. In equity, it's called a suit. That's just like in admiralty jurisdiction, it's not called a complaint. It's called a libel, libel, and whoever files the libel is called a libellant in admiralty. But they've changed all this stuff. They just trying to confuse people, man. The equitable doctrine of laches bars the plaintiff who unreasonably delays in prosecuting a claim or protecting a right has worked. Let me read that over. The equitable doctrine of laches bars the plaintiff whose unreasonable delay in prosecuting a claim or protecting a right has worked a prejudice to the defendant. Before the separate systems of law and equity were merged in 1938, what happened in 1938? What case was that? Erie Railroad versus Thompson. There was a lot of cases, but I've heard Erie Railroad versus Thompson, or whatever it was, mentioned a lot, and they're saying that is the reason for the merger. Before the separate systems of law and equity were merged in 1938, the ordinary rule was that laches was available only in equity courts. And here's the case in support of that contention. I'm going to read this footnote right there. You see that 3? There's a footnote right there. I'm going to read that. The federal courts always had equity powers as well as law power, but they operated until the federal rules of civil procedure told y'all they merged them all into one by distinctively separating equity cases and even had separate equity rules. They merged all of these courts into one court, y'all. That is what they did. So you don't know which hat that this so-called judge is wearing. What is that? Oh, there's a truck out there. I'm going to be studying equity a lot, a whole lot. And I advise y'all to do the same exact thing. I think that's pretty good. I want y'all, if y'all don't mind, just do some research and find out when your particular state merged courts of law and courts of equity. What year was it? They did it in 1973 here. I'm going to find some more cases on that. But anyway, that will be the end of this video. Please, if you haven't already, hit that subscribe button and that like button. That'll be the end of this video. The Supreme Litigant is out. There's the case citation, by the way, for everybody who wanted it. Peace.